How's it going, everybody? This is Anthony Miranda with the Firearms Policy Coalition. Today I want to bring to your attention an update in an important case we had filed a brief in that is currently in the Ninth Circuit known as Duncan v. Becerra. Duncan originates out of the Southern District of California and is a challenge to California's arbitrary magazine capacity limitations. You may recall that the state of California defines magazines that have the capacity to hold more than 10 rounds as so-called large capacity magazines. The state prohibits residents from buying, selling, manufacturing, importing, and possessing these magazines. In 2019, District Court Judge Roger T. Benitez found this law was indeed a violation of the Second Amendment. However, the state of California, unhappy that their laws were deemed to be unconstitutional, sought a stay on the court's judgment and then appealed the case to the Ninth Circuit. Ultimately, the District Court did grant the request for a stay, but found that the magazines acquired during this week period between its order and issuance of the stay were lawfully possessed. The court went as far as to order that California's DOJ issue a notice to all law enforcement agencies in the state to that effect. The week between the issuance of the court's initial order and the stay has become known as Freedom Week by many California residents who took to purchasing millions of magazines during this short period of time. On appeal, the three-judge panel found that California's near categorical ban on LCMs does infringe on the fundamental right to self-defense and affirmed the lower court's ruling. Notably, in its opinion, the panel spent several pages of its analysis considering whether the magazines are dangerous and unusual, an issue argued only in FPC and FPF's brief. In addition to finding that large capacity magazines are commonly used for lawful purposes and thus necessarily not dangerous and unusual, the court engaged in a historical analysis finding that firearms with greater than 10 round capacities existed even before our nation's founding, and the common use of LCMs for self-defense is apparent in our shared national history. After failing to present a prevailing argument to the court for a second time, the state of California sought an en banc review. Today, the Ninth Circuit issued an order that it will indeed rehear Duncan v. Becerra en banc. So if you believe laws like California's magazine capacity limitations need to be abolished, head on over to joinfpc.org and join us in the fight against these 2A infringements. Your donations go directly to helping us fight against these types of things. Once again, this is Anthony Miranda with Firearms Policy Coalition. I'll see you guys next time.